Good morning, everybody. So, welcome to Legal English. Today, we're going to see an article concerning the copyrightability of artwork produced by creative robots and originality, the formality objective models, presented by Minnesota Journal of Law, Science, and Technology. Copyrightability of artwork produced by creative robots and originality, the formality objective models. In our newest era of advanced technology, creative robots driven by sophisticated artificial intelligence systems and hence acting autonomously are capable of producing innovative artists and other works, one which, has they been created by humans, would be eligible for copyright protection. This article addresses the question of copyrightability of artwork created by creative robots. We argue that creative robots as autonomous entities are capable of holding copyright in artwork they produce. However, the greatest hurdle to this notion from the copyright law point of view is the implementation of the most important concept in copyright protection, the requirement of originality. Therefore, in this article, we are revisiting the concept of originality. This article argues that confronting the challenges of new 3A eras, advanced, autonomous, and autonomous, call for the reassessment of the meaning of originality, which is undefined in the field of copyright protection, both in international law, under the Berne Convention, and in domestic U.S. copyright. The lack of a clear definition means that the existing concept of originality is inadequate for addressing new, possible, copyrightable works produced by creative robots. Moreover, the lack of a clear definition leads to interpretation of originality that we are vast, immeasurable, and disharmonized, and already causes confusion in the industry as well as the public. The uncertainty surrounding an important legal concept had triggered a search for a solution that could eliminate or at the very least reduce future conflict. This article suggests that a more formal, objective approach, as opposed to the existing subjective or mixed approach to the concept of originality, should be adopted. The proposed objective approach might be applicable to works created by creative robots as well as artwork generated by digital tools, and is further warranted the intangible, vast nature of art, which suggests that a consistent legal determination of question, what is original, can successfully be achieved only by a formal, objective, descriptive approach. So the part one, can creative robots be an authors of artworks? Subject matter eligibility, the misunderstanding of the current copyright regime, the program of arts, software, and artwork produced by creative robots. Are artwork produced by creative robot derivative works? Defining the undefined, the originality requirement, the international standard in Berne Convention. The standard in the U.S. legal system, originality as constitutional concept, originality and statutory concept, originality as a standard for works, current lower originality standard for works, is a higher standard needed for works. Part 3, addressing formality of originality of artwork, comparing objective and subjective approaches to originality, a formal descriptive approach for originality in artwork, the difficulties in implementing the subject objective, the objective approaches, the audience interpretation of artwork, The resemblance of new artwork to the existing works, adopting a subjective approach, and the current traditional approach to work created by creative robots. And finally, the conclusion. Introduction. 400 years after the death of the old master, Rembrandt van Rijn, a new Rembrandt has been unveiled to the world, or at least the next Rembrandt. The next Rembrandt is a new project that digitizes painting methods of Rembrandt with the goal of creating computer-generated artwork. One exposed to open data and the program will be capable not only replicating existing painting, but also producing entirely new, creative, and original artwork. The project is a result of collaboration between data scientists, engineers, and art historians who are studying Rembrandt painting techniques, his style, and his subject matter in order to build a computer program capable of creating innovative artwork. If human, not digital system, has created such work, it would be copyrightable. But project as Next Rembrandt blur the boundary between the technology and art, creating new challenges to the copyright regime in general. This new reality requires a reevaluation of the concept of originality as applied to artwork. Creative robot driven by autonomous machine artificial intelligence AI system and machine learning software have already become part of our daily life. Automated AI systems play a role in many fields, including diagnostic medicine and transportation, investment, and combat, as well as lesser known areas such as therapy, intelligence gathering, and social policy making. Even legal systems have not escaped the influence of automated AI systems, which play a role in the creation and possibly even the enforcement of legal tools and methods, such as the practice of law, alternative dispute resolution, contract drafting, and more. The production of automated AI machine has been consistently and rapidly grow, with the AI industry forecast to become a 70 billion industry by 2020. The fact that AI industry is also actively involved in the creative production of intellectual property works, including copyrightable works, represented 3A era of advanced, automated, and autonomous digital tools. An unforgettable scene in the film Ex Machina, in which ever a robot gives Callas, a human, a drawing she created, a gift to capture his heart, illustrate this new reality. Creative robots can create original works. One does have neither been copied nor infringed the right associated with other works. However, copyrightable works created by creative robots do not exist only in science fiction movies. Creative robots and other AI-like systems currently produce original works in almost every copyrightable medium: literature, poetry, news, music, and other branches of visual art. The fact that creative robots and other forms of AI systems can autonomously create original works independently of the human being who created the AI system itself raises many legal questions. Are these works copyrightable as original artwork? Who would own the copyright, including all the rights flowing from that ownership, example, licenses, royalty, right to remedy for infringement of the works? Who is entitled to the moral right? Many of these questions depend on the identification of legal entity that can be considered. The creators, we depend on prior discussion about definition of originality. This discussion focus of this article. The AI system of today can be best described as sharing 10 characteristics. They are innovative, autonomous, unpredictable, independent, rational, intelligent, involving capable of learning, and etc. So now we see how they can deal with intellectual property. So what is the originality? Authorship. Talk about subject matter. The misunderstanding of the current traditional copyright regime. The programmer of AI software artwork produced by Creative Robot. So there's many theory approach to this article. Imbaro gene lithography score versus ceremony decision. Originality was described from the author's standpoint. The course defined authors in a constitutional sense as he to whom anything owed its originated matter. The court described copyright as being limited to the original intellectual conception of the authors and stressed the importance of requiring an author to accuse another infringement to prove the existence of those facts of originality, of intellectual production, of thought and conception. Originality as a statutory concept. So now we go to the law. The important concept of originality appear throughout the Copyright Act of 1976 and a judicial opinion interpreting it. We argue that the absence of an express statutory definition has led to the current legal micro disparity between judicial opinion within the United States, which reflect the macro inconsistency between the member states of the Berne Convention. Section 102A of the Copyright Act of 1976 clearly established that copyright protection subsists in original works of authorship fixed in any tangible medium of expression. Although the Act is identified when protecting subsist and especially recognize protection for originality, we state as the definition of original works remain unclear. Indeed, the congressional intent behind the Copyright Act was to leave the originality concept undefined in order to clear the path for court to maintain the existing standard of originality. This were Congress intend to avoid enlarging the contemporary standards of copyright protection. One could argue that congressional inaction should be understood as increasing uncertainty while opening the door for court to manipulate the standard to a higher or lower degree when they deem to be necessary. According to some scholars, Congress intended through the Copyright Act to broaden the range of eligible subject matter and also to align it with the requirement of the Berne Convention. Regardless of what Congress intended, it is clear that the result has been uncertainty regarding the meaning of originality. So we have some article and some case law toward the originality of the works. The formal descriptive approach of originality in artwork. So many case law here. Now we move to some conclusion. The new reality of artificial intelligence have led us to question the originality of works created by creative robots, which might be copyrightable has they been made by humans. This question invited us to rethink the concept of originality in general. We argue that formalizing the concept of originality will improve accuracy in analyzing which artwork merits copyright protection in the digital era. Creating a uniform standard of originality starts at the international level. The Berne Convention was an important step for achieving uniformity in copyright protection. However, the Berne Convention contains poor language regarding the most important requirement for copyright protection, originality. This lack of a clear, specific definition of originality at the international level provide countries with leeway to employ their own national definition of originality. The United States legal system faces an additional self-imposed constraint, notwithstanding the need for monopoly protection of intellectual creation to stimulate creativity and authorship. Excessively pro protection would stifle rather than advance the objective. Although the Constitution manages copyright protection for useful art, Congress, through the Copyright Act, 1976, maintained an undefined concept of originality. The judiciary has therefore been left to create its own standard for originality. Minimum level of creativity is not sufficient to confer originality in artwork. We have argued that originality should be determined by formal objective approach. Under United States copyright law, private property is protected because of the value of its possessors. But considering only value, not a level of creativity and originality invested in works, is unjust. Appreciating the value more than the labor could lead to a purely aesthetic analysis. United States jurisprudence specifically deal with aesthetics in artwork. In proposing a more formal descriptive framework for artworks, this article suggests avoiding the aesthetic approach, example appreciation for beauty, currently employed by judge. Just personally explain the aesthetic approach. Artistic originality is not the same thing as the legal concept of originality and the Copyright Act. Artistic originality indeed might inhere in a detail, a nuance, and setting too small to be apprehended by a judge. The quantum of originality in artwork should be determined by a descriptive analysis that evaluates the expression without ignoring the effort. Applying our proposed framework to the facts that of the X mono demonstrate this soundness. From a subjective perspective, Miss Gimenez intent was to restore and not to create. But contract from objective perspective, the audience did not consider her works to be restoration. The audience deemed her creation to be an entirely new artwork that added value to the first work. Many of the best value intangible are the result of moments of inspiration that involve little or no apparent effort on the part of the person claiming the intangible. The work of persisting but not a spy creator would be protected by law. The objective perspective thus captures the external relationship between the expression, the audience interpretation of the artwork, and the resemblance of the expression to other works. In addition to providing guidance to judge and juries, a descriptive approach will pave the way for an impartial originality standard. A formal descriptive analysis is capable of adapting to the specific act of a case, including a digital authors. Due to uncertainty, if not complete lack of formal originality requirement in artwork, this article encourages countries to implement command guidelines for assessing originality in artwork. Such guidelines would produce more uniform and just outcome for artists, which would in turn foster their continued creativity. Moreover, such frameworks would make possible in case we utilize to keep rather than new defined copyright law in the future for the work produced by creative property to be copyrightable. This conclusion is just the first step. Once we recognize that the work produced by creative properties may be copyrightable, we must ask who, if anyone, should be entitled to hold copyright protection on behalf of Robert. Should we apply traditional copyright law to work created by creative property, or should we create new legal tools? If the latter, should the tool be international or national? What would happen in the case of infringement by creative property? Can creative property follow ethical rules? Who should be responsible for pressing the stop button on such machine? This question reflects just the tip of iceberg of the new era we have entered. The study and further research are needed in order to avoid putting the cart before the horses. Thank you for your understanding. Mình take a report from YouTube channel.